Hey there, Pete again. Welcome, viewers, to this episode. We are still on social foundations and perspective of law. Today, I would like to begin talking about the schools of thought. Schools of thought that I would like to begin with. One, natural law school of thought. There's nobody other than St. Thomas Aquinas, an Italian Dominican Catholic priest, a theologian, a philosopher, a moralist, who better explained to us the understanding of law from the moral perspective. St. Thomas Aquinas divided his understanding of law in 4 categories. First category, lex divina, divine law. Second category, lex eterna, that is eternal law. Third category, lex naturae, that is natural law. And finally, lex humana, that is human law. In lex divina, St. Thomas Aquinas had clearly thought of the supernatural being, God in this case, the divinity that is the author or the legislator of the law. And he gives that law to his people. His people have got only to obey that law and keep the legislator happy. This is the law that man has got no say on. Man cannot change it, cannot amend it, cannot appeal it, cannot challenge it in court. It is lex divina. It is divine law. That one also was depicted in the traditions in the past in which the kings were seen as people sharing the divine powers. And that's why the decrees from the kings were not supposed to be challenged by any of the subjects. Good. Back to St. Thomas Aquinas. Lex eterna, or eternal law, is the law of nature, the law of physics, as we call it, or the law of sciences. It is slightly different from the precepts of God in the lex divina, in which God gives the ordinances to the people to follow. In the eternal law, it is the law that is perpetual. It will always be there and is found in the nature, how the nature behaves. Well, he explains this better again in lex naturae, that is natural law. Natural law, St. Thomas Aquinas, in his philosophical postulation, sees that human beings are endowed with rationality. Here he concurs with Aristotle in the fact that human beings are rational beings. They are beings capable of reasoning, thinking logically, and acting on what they have in mind. So the mind, the conscience, the will that empowers people to carry out certain actions is what makes St. Thomas Aquinas elaborate further on the natural law theory. So within our nature, there is inbuilt, we are born with certain capacity to understand and make certain judgments in our actions. This is the nexus of the relationship between the law as we know it and the morality. That besides the law, there is also our inbuilt power, or not intuition of course, but inbuilt power to intellect, to look at, to rationalize about certain actions. And this is within our nature. He gives a good example about the procreation, The procreation that is in nature is a dictate of natural law. It is not a dictate of human beings, and things procreate, and that's the continuity in our natural space. And it is good that St. Thomas Aquinas has brought about this kind of understanding to build our broader knowledge on the understanding of the jurisprudence and the study of social foundations. Well, Aquinas comes to another way of looking and understanding law as man-made law, that is lex humana, that is human law. Human law that Aquinas had in mind is that man can make rules and principles can be adopted to govern his environment in terms of policies and in terms of agreeing to do and not to do certain things, and that is regulated within our social context. And St. Thomas Aquinas puts again the human capacity to reason, to rationalize in this conception of lex humana. Lex humana is not eternal, it is not divine, it is man-made. And we can see that right in the legislation making process. We can see that in the statutes. We can see that as well in the Constitution. And in that case, St. Thomas Aquinas was right and in his thinking that such legislation should also go through the moral judgment in terms of good law and bad law. Now, what again explains the natural law school of thought is the judicial systems that are distinct in themselves. The natural school of thought, or the natural law school of thought, tend to adopt inquisitorial system in which the judge, the arbitrator, or the magistrate, magistratura, is in charge of the judicial process or the trial. The judge can order for more investigations to be carried out if he requires. The judge can as well question the parties in order to understand the veracity of the facts and evidence presented in court before making a final ruling. Inquisitorial systems believe in the presumption of guilty till proven innocent. We are all guilty until we are proven innocent. And that is why when a police officer approaches one in such circumstances, it is the person to prove innocent, but the prosecutor assumes or presumes that the individual is guilty. In the opposite, we find in the common law traditions that the adversarial system puts it on the contrary. We are all presumed innocent, to be innocent, till proven guilty. That means one must go to court to bring a case. But in the inquisitorial system, it is not always the same that one must go to court. The court can also go to an individual and open investigations. So these systems operate in different various countries. We know that all this comes from the European traditions. We have the continental Europe adhering to the traditional Roman civil law code and the code of Napoleon Bonaparte, the French dictator ruler that ruled for some time and imposed Napoleon civil code upon the empire, the area that he conquered. And in that case, we find the French Roman civil law code being again replicated and adopted in the Francophone African states that were formerly colonized by France. And the formerly colonized states by Belgium also adopted the natural law school of thought, in the sense that their system is that Roman civil law system. Well, such kind of distinctions are going to be explained further, but in this sense we find that in the common law system, the judge is considered to be impartial, should not be knowledgeable about the case before the bench, and the parties are the ones to bring facts, evidence, and make the argument. In this case, the judge is disarmed. The judge is disarmed, and the judge doesn't interrogate or question parties directly, but tends to be impartial and respecting the principle of the presumption of innocence till proven guilty. Well, in today's brief synopsis lecture, it was about introducing the schools of thought, and we started with the main one, the natural law theory school of thought, and the exponents and proponents of this theory is one not other than St. Thomas Aquinas. We followed with the neo-naturalist theorists such as John Finnis, such as Donald Dworkin, and many other thinkers, both in the modern time, in the 20th and the 21st century. We are going again to carry on with the discussions and presentations on other schools of thought, but for your understanding, the natural law school of thought is the major one. We'll follow up with the positivist law school of thought and the realist law school of thought, and finally we'll conclude with the sociological or historical law school of thought. Thank you for watching this video presentation. We ask you to keep on promoting and encouraging these presentations. Thanks so much, and keep safe.